Hello everyone, it is July 22nd, 2020 as we film right now, and the eviction tsunami is here. So if you are a nervous tenant, or maybe you are a kind-hearted probate lawyer whose cousin just received an eviction lawsuit, watch on, because eviction legal actions are unlike any other. You have to know how to fight them. So let me begin with two disclaimers. First, I slant pro-tenant, so landlords out there, I understand that you're probably very frustrated and you have problems and you have a mortgage to pay. Trust me, I understand that, but I'm kind of tenant oriented and that's what this is focused on. Second, landlord-tenant laws vary state by state, and I only have time to give you the important things that you need to be aware of in this legal brief. Otherwise, it will become kind of like a legal long, and no one likes that channel, so I'm gonna have to keep it simple and straightforward. Okay, so we have to kind of start with a sad statistic. According to this article from CNBC, over 32% of households failed to make all of their rent payments in July of this year, right before all of the eviction moratoriums are ending. That's 32%. And now it looks like Congress is not going to approve the additional 600 unemployment payments per week. And so this is just going to be horrible. I heard from a lawyer friend of mine that does evictions for landlords that she has about 500 cases to file next month, 500 eviction actions, and she's just a one small person law firm. So the wave is coming, and here's the things you have to know. 1. An eviction case moves much quicker than any other kind of lawsuit. Landlords long ago got legislatures to speed up the process of eviction, and perhaps rightfully so. Lawsuits, regular lawsuits, take months, years to complete, so eviction lawsuits are super streamlined. Upon receiving the eviction lawsuit, you only have days, sometimes as little as 5 days, to respond and avoid a default. So if a client calls you a week after the eviction lawsuit is served, forget it, it's too late. Massachusetts is one of the more lenient jurisdictions, and look at how tight the litigation process is. You have to answer the complaint in 7 days, and the trial is within 23 days of the answer. So the whole litigation process, including discovery, is designed to be completed in 30 days. Next, landlord-tenant law is focused on pre-suit requirements. State laws go into much detail and have very complex laws on what a landlord must do in order to evict a tenant. The laws require notices served or posted within a certain number of days after non-payment. The first notice is a notice to pay rent or quit, and this is what is served when you miss rent. You can see in this example form that not only must the landlord put in the exact amount of rent that is overdue, but must also put in the exact date that the tenant must move out, and he must or she must serve it in very specific ways. Now, because statutory pre-suit requirements are strictly construed, the very first thing you look for is whether the landlord put the exact correct amount of rent that is owed and put the correct move-out date. If anything is off, that can be a complete defense to the eviction lawsuit, forcing the landlord to start all over and having the lawsuit dismissed. Hint, how was the tenant given notice? That's something that they'll often mess up. So, failures of condition precedent is your first line of defense. The next thing to keep in mind is that if you're going to attempt to argue over the amount due and owing, you almost always are going to have to deposit the disputed rent with the court. So in case you lose, the landlord will get paid. Now this is usually going to be a losing proposition in these coming months, especially because the problem is that people don't have jobs and don't have the money to pay. So putting the rent into the registry is a no-go from the get-go. So that's something you're gonna have to keep in mind. Most of the time, if you don't have the money to pay rent into the court and you can't find an exception, you are going to lose as though you hadn't even answered the complaint. This is key. I mean, you won't even be able to say anything to the judge. No money, no argument. Remember that. But in every state, there are exceptions to this rule. And again, I don't have time to go into every state's law, but look at the Florida statute, for example. Here you can see the requirement that the disputed rent be paid into the court registry. But hiding in there, if you really look hard, is an exception. You have to pay into the registry or, and I love the word or file a motion to determine the amount of the rent. So your job in fighting an eviction is to look at the landlord-tenant statute in your state and find the exceptions to the deposit rule. Fitting your argument into an exception will allow you to fight the eviction without having to pay the full amount of rent. And even if you lose, it will buy you time. And if you cannot find a defense or you lose in court, the final arrow in the tenant defense quiver is bankruptcy. The automatic stay when you file bankruptcy will stop an eviction right away. It is then required of the landlord that he or she ask the bankruptcy court to lift the stay and allow the eviction to continue. In my experience, a bankruptcy petition can allow a tenant to get out from other onerous payments and bring the landlord to the table as far as working something out with them, because now you've added a layer of difficulty to kicking you out of your place. If anything, it requires the landlord to find a lawyer admitted to the bankruptcy court in your area, and that alone takes time. So remember, you have to move fast in defending eviction, look at the landlord's pre-suit requirements very closely, and find an argument that doesn't require you make payment of the rent. And if all else fails, think about bankruptcy if things are that bad. I know times are bad for a lot of people right now. Take care and best of luck to you and yours.